So, how important are instructions for how a jury decides its verdict? In our drama, you obviously heard a very abbreviated version of this phase of the trial. We only had a few minutes to show you what happened in the trial, not several days, weeks, or even perhaps months, as happens in real trials. In some jurisdictions, the summing up and instruction part of the trial can take a substantial period of time, even as long as the presentation of evidence itself during the trial. This is one of the reasons that law reform bodies and researchers have focused on understanding the effect of this part of the trial. Longer summing ups and instructions to jurors make the trial more expensive and create unnecessary delays in the legal system. Let's ignore the summing up part of the trial for a second and focus on the issue of judicial instructions. Are those instructions, or directions as they are sometimes called, useful for jurors in making their decisions? Well, to answer that question, we have to first of all ask whether jurors can actually understand what they're being asked to do. McCabe and Purves, reporting on the London School of Economics Jury Research Project in 1974, asked shadow jurors about their experiences. A shadow jury is when members of the public attend a real trial and form a second jury for the purposes of the research project. They're not actually deciding the verdict in the case, but they experience the same evidence as the real jury. Typically, they sit in a public gallery. Because they're not the real jury, researchers are allowed to record their deliberations and ask them lots of questions about how they make their decisions. This research suggested that jurors are conscientious about their task. They try really hard to do what they've been asked to do. However, research by Stevenson in 1992 suggested that this conscientiousness fades away during the trial, unfortunately. This doesn't say a lot about jurors' comprehension of what they're asked to do, only that they appear to be motivated to do what they think they're being asked to do. Zander and Henderson's 1993 study reported that 90% of 8,000 jurors had been able to understand and remember the evidence, and that the prosecution and defence barristers thought the jury would have no trouble understanding or remembering the evidence. That research relied on jurors' own self-reports of comprehension, whether they thought they could understand the evidence and judicial instructions, and also the reports of the lawyers involved in the case. Other self-report data agrees with these findings. In a study by Jackson in 1992, 65% of jurors said they understood all of the judge's instructions, and a further 25% said they understood most of the instructions. So that's a total of 90%, much the same as Zander and Henderson found. Consistent with this, Cutler and Hughes in 2001 reported that 96.6% of jurors in their study said that the judge's instructions were clear and understandable. Now, from a research perspective, even though this is interesting in that it tells us what jurors think they understand, it might not be a very reliable indicator of actual comprehension. So why can't we rely on jurors' self-reported understanding of instructions? There's a pretty strong social pressure on a juror to say that he or she understands the task at hand. To return a verdict and then admit to a researcher that you didn't understand what you were meant to be doing would look pretty bad, really. The research relying on more direct measures of comprehension is generally pretty consistent, and unfortunately it paints a different picture about jurors' comprehension of instructions. Such research has either asked jurors and mock jurors to paraphrase what the judicial instructions mean. This is a test developed by Charro in 1979, or has given jurors and mock jurors a multiple choice test. When we asked you what the judge's instructions meant at the start of the episode, we asked both of these types of questions. The short version is that jurors struggle to understand what they're asked to do. For example, Reifman, Gussick and Ellsworth in 1992 reported that only 41% of jurors actually understood the substantive law when they were tested objectively. They also showed that those jurors who were given instructions performed just as well as those who were not given instructions. So either comprehension was poor or jurors didn't actually rely on those instructions. In terms of understanding both of the instructions we spoke about earlier in this presentation, our own research suggests that only about a third of jurors correctly interpret both of the instructions to do with standard of proof and burden of proof. 2/3 understand one or the other. These are not unusual findings. Work by Severance and colleagues in 1992 also shows that jurors display serious difficulty comprehending differences between legal concepts. As reported by Surratt in 1995, jurors who were surveyed as part of the Capital Jury Project could remember the details of the defendant, but they could not understand or remember the legal rules relating to their decision to impose the death penalty. This difficulty in remembering the legal rules is part of a more general issue where jurors have difficulty in remembering information about trials. For example, Hastie and colleagues' 1983 study found that jurors had poor recall of trial information. This problem is made worse in complex cases, according to some research by Nathanson in 1995. Now, jurors themselves have some insight into the problems with the evidence and instructions. Hewer and Penrod found in 1995 as well that as case complexity increased, jurors felt less sure that their verdict reflected a proper understanding of the instructions. Hewer and Penrod in 1994 also surveyed 81% of jurors in 160 trials. They found that as the amount of information increased, jurors admitted that it was harder to decide the case. And so difficulties in remembering trial details and also the legal instructions about how to decide the verdict make it difficult for jurors to do their job. There's additional evidence from Sandy's 1995 study that jurors fail to separate judgments of guilt and punishment in capital cases in the United States. Although the guilt and punishment phases of capital trials are meant to be separate and the decisions based on different sets of evidence, it seems that both decisions are made at the same time. We also know from Casper and Benedict's 1993 research that jurors do not ignore extra-legal or inadmissible evidence, even when instructed to do so. We spoke about some of these issues in a previous presentation. So overall, while there is some variation in comprehension from study to study, according to Bornstein and Green in 2011, figures of about 50% of people actually understanding directions seem to be about typical. From Rose and Ogloff's 2001 research, we also know that deliberating as a group doesn't seem to improve the state of affairs. So this is obviously somewhat concerning. The point of this research is not to suggest that jurors are incapable of acting as deciders of fact, as they've been instructed to do so, but rather to highlight that there was a problem with how they're being asked to do their job. So there is a problem with the instructions, not with the jurors themselves. Just to give you an example of how complex the instructions have become in some cases, here's an instruction about motive to lie.
There are a number of matters that arise out of that line of questions and the argument about which I must give you direction. The first is this. The defence argued to you that there are a number of reasons why complainant A might be telling lies about the conduct of the accused to him. The prosecution, on the other hand, of course, argued that complainant A was a truthful witness, and you should accept him as a witness of truth in relation to what he says the accused did to him. The prosecution argues that even accepting the combination of events occurring in complainant A's life at the time, that this does not make his evidence untruthful or unreliable. It is very important that you understand that if you accept the prosecution argument that notwithstanding all of these things were happening to complainant A at the time, and therefore that you reject the defence argument that complainant A was lying because he wanted to divert attention away from his own wrongdoing and to get himself back into the school, and because people were trying to induce him to say things about name withheld, if you reject that defence argument, all that means is you have rejected one of the arguments advanced by the defence as to why you should reject the evidence of complainant A. It is not the same by rejecting an argument that these were motives that induced complainant A to lie. It is not the same as saying, because I have rejected these motives, therefore I find he was telling the truth. So it is one thing to say, I reject the argument that he lied because he had a motive, but it does not automatically convert complainant A's evidence into the truth. That is a separate and independent assessment that you must make.
Two things flow from that. First is the one I have mentioned. All you have done, if you reject the argument, is reject one possible basis for rejecting complainant A's evidence. It may still be possible that he was lying for a motive that you do not know about, and that the defence did not know about. So just because if you reject the possible motives advanced by the defence, does not mean that there could not be other motives. So the rejection of arguments about motive to lie do not make complainant A's evidence by that reason alone any more credible.
Now, right, obviously we had to speed up the instruction. If we had read the instruction out at normal speed, it would have taken about 30 or 40 minutes. So why have instructions become so complex when this complexity seems to be at odds with the very purpose of helping jurors make their decisions correctly? Well, the reason why this is because instructions are often designed and given with two purposes in mind. The first purpose should be pretty obvious, to help jurors make decisions in the legally correct way. The second purpose, however, is to protect the jury's verdict against appeal. Courts are generally arranged in a hierarchy. The lower courts will hear the less serious matters and also the preliminary matters for the more serious cases. The higher courts, such as the District Court and the Supreme Courts in my jurisdiction, will run the jury trials for the serious crimes. At the conclusion of a trial, if a defendant is convicted, he or she may instruct their lawyers to appeal to the Court of Appeal or even the High Court if the result of the first appeal is to be appealed. The High Court is the highest court in Australia. The equivalent in other jurisdictions will likely have a different name. Because a jury doesn't provide written reasons for their verdict, as in a judge-only trial, the only basis for appeal is generally misinstruction or misdirection. That is, that the judge gave an incorrect instruction or failed to give an appropriate instruction. Because jury trials are very time-consuming and expensive and they can be traumatic for witnesses and victims, judges generally want to avoid avenues for appeal in jury trials. One way they do this is to rely on directions that have been written to protect against appeal. These might be standard instructions that have survived previous appeals, or instructions that cover every possible verdict option and defence, even if not raised in the actual case. Such instructions can be very lengthy and contain a lot of technical legal language which is aimed at the appeals judges, not the jurors. Entities such as the American Bar Association and law reform commissions in other jurisdictions have recommended rewriting instructions in simpler terminology so that they are easy to understand.